Welcome back to the Law Show. We are interviewing the candidates for Michigan Supreme Court race in 2012, Judge Connie Marie Kelley of the Wayne County Circuit Court Family Bench and Judge Shelia Johnson of the 46th Judicial District Court in Southfield. And I want to thank you folks so much for coming in to talk to our listeners. It's so hard to explain to people why it's important for them to be concerned about the Supreme Court elections. And a lot of people actually think that if they vote a straight party ticket, Democrat or Republican, that they're actually voting for the judicial candidates, the Supreme Court candidates, and that's not true. Can you address that a little bit?
Oh, yeah. Well, you want to go first?
Okay, I was just going to say, that it is confusing to voters because the way the law is set up in Michigan, you have to be nominated by a party, a political party, but then your name appears on the nonpartisan section of the ballot. And I think in great part that explains the drop-off rate from the people who go to vote for president to the people who vote for Supreme Court. Sometimes that can be as high as 30 to 40% of the people that vote for president do not go on to vote for the Michigan Supreme Court. And I think in part that's because people think if you're nominated by the Democratic Party and they vote straight party ticket, then they voted for you. The same with Republicans. But it's not true, and I have to tell people over and over again that voting straight ticket is not a vote for any judges, not just the Michigan Supreme Court, but your district court judges and your circuit court judges. So everybody has to go on to the nonpartisan section of the ballot to vote for a judge.
So that means look further down the ballot and find the names of the judges. And the names that they want to look for are Connie Marie Kelley and Judge Shelia Johnson and Bridget McCormick.
Right, Bridget Mary McCormick. And what we tell people is you have to circle in our names. That way you'll know that you've actually cast a vote for us if you actually circle in the names. And the judges are on the back of the ballot in most cities and communities.
So if the listeners out there are listening and you're getting ready to vote, or if you're getting ready to fill out your absentee vote, make sure you vote for the justices, whoever you want to vote for. And it's our belief that the best candidates in this race are McCormick, Johnson, and Kelley. But you want to make sure and actually cast a vote. Otherwise, you're wasting your vote, and you just don't want to waste a vote. So one of the things I wanted to talk about now, Your Honors, is to talk a little bit about the current Supreme Court. We've heard lots of different things from lots of different people. Professor Sedler has been very outspoken about the current Michigan Supreme Court. There have been studies done by such as the University of Chicago ranking the Michigan Supreme Court for independence of thought and judgment as dead last, number 50 out of 50 state Supreme Courts. Terrible, terrible things I'm hearing about this. Can you tell me, what is it about the Supreme Court as it currently stands that's drawing all of this criticism? Is it politicization? Is it adherence to more special interests? I've heard that in some of the ads, I've heard that our current Supreme Court makes decisions that go along with insurance companies more than 85% of the time or 80% of the time. Can you address this, Judge Kelley?
Well, I think that's the crux of the study, the University of Chicago study. It rated the Michigan Supreme Court 50 out of the 50 state Supreme Courts in our country for independence and for having their productivity and the weight of their opinions, whether other states look to them as courts that they wanted to model themselves after. And 50 out of 50 is pretty sad and pretty depressing. There was another more recent study by the Center for American Progress, and again, that study examined 6 states, including Michigan, and they looked at cases where individuals had cases against corporations. And for the period of time that they studied, they found that out of 134 cases decided by this Michigan Supreme Court, 105 of them were decided in favor of the corporations, 105 out of 134. And so I think that, the public in general and lawyers in particular have a perception that the current makeup of the court is way more likely to decide for corporations and insurance companies than they do for individuals. And, the studies have been done that show that Justice Markman in particular, in one area of the law, which we call first-party no-fault benefits, that is where you pay your insurance premiums for your own auto coverage. And when you're in an accident, your own insurance company pays your lost wages and your medical bills resulting from that accident. And in the major cases that he has decided, 26 cases, he has decided in favor of the insurance company 26 times out of 26, denying these individual people the benefits that they have paid for years and years. So I think the perception, as I said, and lawyers in particular have a perception that this court is unfair to individuals.
Yeah, I would agree with that too. I just wanted to chime in and say that it's not really a joke, but I think it started out as a joke that lawyers would say, well, I can predict the disposition of the case without knowing any of the facts or anything whatsoever other than the names of the parties. And we can pretty much predict that this case will be decided on the side of a corporation or a business entity. And that's really a sad statement for really what's supposed to be perceived the unbiased nature of the judicial system, period. And it really does not bode well for us as a state to have a court with such a negative reputation. And I think also not only are the statistics such as what Connie said, but when you look at how many of these decisions seem to be an abrupt change in the law, where the law had been flowing a specific way, the opinion somehow changed the course of the law without any reasonable, well-grounded opinion in the law to explain why they departed that way. And so I think overall the feeling is that there is an appearance that the system is really geared towards special interests and the people who have supported those justices and not for the people of our state. And I think that's why we're all three running, is to make sure that we bring a fresh, judicially independent approach with a broad perspective, with no preconceived concepts or notions on anything, but to apply the law as fairly and be as open-minded and really give a just decision for all of the citizens, not just for special interests.
You know, that brings to mind a concept that I've been hearing from a lot of the, well, I heard it in the last election for Supreme Court from Justice Young. He kept calling himself a rule of law judge. And I know of many, many cases where he made decisions without regard to the body of equitable law. That's the law that applies concepts of fairness and honesty and what we would expect to, a way to treat our fellow man. And then there's the concept of the common law, and then there's the concept of the statutory law. So can you address for me what really is the true definition of a rule of law judge, and how are you going to be a rule of law judge?
Well, a rule of law judge is sort of a phrase that they have coined for themselves. And I like to say that just because you call yourself a rule of law judge doesn't make it so. I think you have to examine a judge's body of work, the opinions they've written, and the basis for those opinions to really determine whether a judge is a rule of law judge. I mean, of course, we all say we are going to follow the law, and we are going to follow the law. But I think putting that tag on yourself is intended to convey a meaning that it doesn't necessarily mean that it's so. And so I think that people shouldn't take that as face value.
It brings me to one of my other questions that sort of dovetails for a question that I've got for you, Judge Johnson. Recently, there was a case called Dufresne. And that is a case where a man was in a very serious car accident, so serious that he became in a coma. And he was in a coma for about, I think, 6 months and ultimately died. He never came to. And it was what we call a hit-and-run accident. And he had the ability to, or he had coverage under his State Farm insurance policy to make a claim for uninsured motorist benefits. But the policy required him to notify State Farm that it was a hit-and-run accident within, I think, like 30 days. But he couldn't do it because he was in a coma in the hospital. So isn't that a place where the court of equity would say, you know what, we're not going to hold him responsible for adhering to that contract because it's impossible. He's unconscious. We can't. But that's exactly what Judge Zara did. He said, I don't care if he's unconscious. I don't care if he can't talk. I don't care if he can't think. Judge Zara said, we're going to make him respond and give that notice as he's required to give it. And I don't care if he's in the hospital in a coma. Can you address that issue?
Well, I think that you've summarized the facts and circumstances of the case fairly well. And I think that that's where one of the things that the courts should do is look at what's equitable as well as following the law. And I wasn't privy, obviously, to the briefs that they submitted in that case, but I would have thought that the impossibility of the circumstance would have been a factor that common sense would have come into play, and that the court would have looked at this, ruled more accordingly, that in this particular instance, when the person person was factually impossible to be able to meet their provisions under the contract, that the contract would not have been applied in its literal manner to preclude a potential recovery. And this is not the only case that's out there that the Supreme Court has ruled in a very similar fashion. There's another case, and quite frankly, I can't remember the name, but this involved the murder of a University of Michigan professor. And quite frankly, she was raped and murdered, and I think it happened in 1986. And there was a statute of limitations that would have been 3 years up to 1989. And but no one had solved the crime, and no one knew who it was that was the perpetrator and who the person was to be sued. And so that occurred in 2000, I believe, or 2002, one of those 2 years, well beyond 3 years after the fact. And the family wanted to bring a claim for the death of this person and recover some damages from the perpetrator of the offense. Knowing that this person had been found guilty, wanting to redress any possible damages that they had, the Supreme Court said no. Even though you didn't know who to sue, your time to sue them had lapsed 3 years back in 1989,
and
which
so
is ridiculous.
That sort of goes counter to the old rule of the discovery rule. There's something called the discovery rule that tolls your statute of limitations until you have reason to believe not only the facts of the crime and the facts of the case, but who was responsible.
Right.
We're going to take a short break. When we come back, we'll continue our interview with the Supreme Court candidates, Judge Shelia Johnson of the 46th Judicial District Court in Southfield, and Judge Connie Marie Kelley of the Family Court Bench in the Wayne County Circuit Court. I'm Brian Dailey, broadcasting live from high atop the Law Show studios in the undisputed automobile capital of the world. We are not taking calls today, but we will answer your questions if you call the regular number. We have lawyers standing by ready to answer your questions. I'm Brian Dailey. We'll be right back after these few short messages. Please stay tuned.